Hey everyone, happy Friday. It is the first Friday of October. Hopefully everybody is enjoying their fall. I've got my nice little fall candle here. I don't know if anyone else likes scented candles during the fall, but I do. Helps bring in the season. So my name is Irene Lee. I'm one of the senior attorneys here at McEntee Law Group. My practice focuses on business or employment-based immigration, but our firm has expertise in a wide range of immigration issues, or as sometimes I like to call it, the alphabet soup of visas. Across our team, we have amazing attorneys and legal staff who work on everything from employment-based visas, family-based visas, humanitarian cases, as well as cases for those who are in sports, arts, and entertainment industries. And on the first Friday of every month, we like to go live on our socials to give you the latest and greatest in what's going on in U.S. immigration. But before we dive into today's First Friday, there are a few housekeeping items I should mention. Number one, this is just a friendly reminder that I am an immigration attorney, but I am not your immigration attorney. That is unless and until you reach out to directly work with me or our team. This live stream is only intended to provide general information and is not meant to be legal advice for you specifically. If you have any questions about your immigration status or your options, you can reach out to us or book a consultation with our team. Our attorneys have a lot of experience in all things immigration, so we're happy to help you if we can. In addition, number two, if you plan to post a public comment or a question, please make sure not to post anything personal or private in the chat threads here. This is a public forum, so we want to make sure that we protect your privacy. Lastly, at the end of today's updates, we'll leave a little bit of time for some Q&A. So if you have submitted a question or want to hear what others are curious about, please stay tuned. Okay, so we are going to go ahead and get started now that we have all the basics covered. For those of you guys who are watching, U.S. immigration is a lot of things, but one thing it's definitely not is boring. So this month's updates are no exception. We're going to start at the top with the government shutdown. Many of you know this week, Congress unfortunately did not come to an agreement on a budget proposal for this upcoming fiscal year. And so when this happens, unfortunately, the government is required to shut down. So as of Wednesday, October 1st, the US government officially went dark or shut down. Every year this happens. Unfortunately, again, if there's no kind of agreement on this budget, right now there is no kind of indication of when this budget agreement will come, when the shutdown will end. But the longest shutdown in history was 35 days. So we're hoping that it'll be less than that, but we'll just have to see. When a government shutdown happens, there's a lot of different things that go on during this time. Some of the government agencies are required to be shut down completely. There are other agencies that are still operational. So I'm going to try my best to go through all of the agencies that might affect you or an immigration case that you're working on so that you have a better understanding of what will happen to those cases during the shutdown. So first things first, Department of Homeland Security. That work is considered essential, so the department will stay open for the most part. USCIS, the agency that adjudicates all the applications that are filed here in the United States for the most part, and that will stay open, thankfully, because it is a fee-funded agency. So that just means that when the government is shut down, generally it's business as usual. USCIS doesn't really rely on Congress for funding, and so they can continue to pay their workers based on fees you submit as part of your application. So if you have a visa application that's pending with USCIS or you plan to file one very soon, you can kind of relax and know that your case will still continue to be processed. There are going to be certain programs that are related to USCIS, however, that will be affected. So for example, E-Verify is one of them. E-Verify is federally funded, so this will be suspended during the shutdown. That being said, there are other ways that E-Verify employers can complete I-9 verifications right now. So if you have a specific concern about a program like this, please reach out to our team or another experienced attorney. We can walk you through that. I'm drinking my coffee so we can get through the rest of these updates. But The Department of State is another big agency that I know many people will want to know about during the shutdown. The Department of State covers all of the consular operations all around the world. So that means when you're planning to go for a visa stamping appointment, and receive your visa stamp, that's the department that essentially oversees all of that. So thankfully, most of the Department of State and consular offices around the world will remain open. And that's because, like USCIS, consulates are generally fueled by fees. That said, if you have plans to travel or you are planning to go and schedule a visa appointment during this time, I wouldn't necessarily jump on a flight just yet. Reason I say that is because depending on how long this shutdown lasts, again, I mentioned that the longest shutdown was 35 days. Consular services could at some point be affected. So if there's just not enough fees, for example, coming in to support operations at a particular post, offices have been known to limit some of their services to things that are absolutely urgent, like diplomatic visas or life or death emergencies. So bottom line is, even though consulates are still open, it's not guaranteed that, all of these offices won't be affected in some kind of way. So in other words, if you don't absolutely have to travel right now, best not to, and kind of stay put, or maybe consider going to Hawaii. Hawaii is pretty beautiful this time of year. Okay, CBP, Customs and Border Protection. So just like the Department of State, CBP is going to be operational during this shutdown, meaning officers at the border and our ports of entry and airports are all open, so travel can continue. That being said, similar to the Department of State, government shutdowns can affect different, things like air travel in different ways. So, if you don't have to travel, please don't. If you do have to travel, just expect that there could be some delays at the airports, especially for those who are applying at pre-flight inspection offices for your visa. There could be some delays or disruptions in service. So just keep that in mind and plan ahead. ICE, Immigration and Customs Enforcement. Now, I know most of you probably know what ICE is. They have been all around the news lately, especially under this administration. Immigration and Customs Enforcement will keep enforcing immigration laws and continue with removal operations as usual. They will still be operational. So that also includes the SEVP program, so the Student Exchange and Visitor Program offices. Those will remain open, so that's good news. So students and exchange visitors should be able to continue to keep up with their requirements and reach out to those offices if they need to. Anyone who has an immigration court case, whether detained or non-detained cases, those cases will continue to move forward as usual. In the past, there have been different types of cases that have been suspended during the government shutdown, but this year, both detained and non-detained cases are moving forward. So that's good news for the most part for some of you. The Department of Labor now is a different story compared to some of these other agencies. The Department of Labor is federally funded, and their Office of Foreign Labor Certification, or OFLC, as most of us call it, is completely suspended. So the OFLC system is the website where we submit things like labor condition applications, or LCAs, for H-1Bs. It's also the system that we file perm cases, so green card related perm cases and other types of applications. Unfortunately, during this shutdown, the website itself is down, so you cannot log in, you're not able to access files, and you cannot file anything new. This also means that any applications that were filed before the shutdown happened and wasn't certified by the time the shutdown started, unfortunately, they will have to just kind of stand still. They're a little bit frozen right now. And hopefully, as soon as the shutdown is lifted, those applications will continue to process as normal. Now, Congressional Constituent Services and CIS Ombudsman operations. So there might not be a ton of you who are maybe doing anything with either of these offices, but these services are going to be paused during this time. So if you are looking for, Congress to help you out with a particular case, or you are waiting to hear from the Ombudsman's office, just know that that will unfortunately be disrupted or delayed during this time until the shutdown is lifted. So all that said, that was a very big update, but what should we expect going forward? So the bottom line is some immigration services will keep operating, like border entry, enforcement, court hearings, and applications with USCIS. But the key processing at the Department of Labor, for example, especially with labor certifications, unfortunately is paused right now. That also means filings that require DOL approvals will be delayed. So H-1B petitions that ordinarily would be able to be submitted with USCIS right now won't be able to be filed unless there is an LCA that's certified. So stay tuned for more updates on the government shutdown and how that might affect your case. Travel and interviews also might face some slowdown. So just, again, avoid non-essential trips if you can. And most importantly, stay in touch with your lawyer or our team if you work with us, and keep an eye out for updates as we kind of receive them during the shutdown. And fingers crossed, most importantly, that this doesn't last long. Okay, next update, we're going to talk about some really big changes to the H-1B program. So a lot of you out there are either H-1B holders, H-1B hopefuls, or companies who have a lot of H-1B employees. And this news is definitely something that is relevant for you. So a couple of different updates that we will share today. One is something that I'm sure many of you who are in the H-1B world know about. And this is what has become sort of an infamous presidential proclamation in the last couple of weeks, caused a lot of stir in the media and unfortunately a lot of panic initially among H-1B holders. But on September 19, President Trump issued a presidential proclamation that affected H-1B holders, and that proclamation took effect September 21st. So if you all remember, September 19th was a Friday. This announcement came out late on a Friday afternoon, which happens to be a very Trump-like announcement to come out right before the weekend. And it did take effect on Sunday. So what happened with this proclamation, some of you know it as the $100,000 fee rule. So specifically, this proclamation stated a couple of things. Number one, it restricted the entry of those seeking to enter H-1B status unless they paid what I think a lot of us would agree is an astronomical fee of $100,000. Now, I don't know about you all, but for those of you who know how much it costs to file an H-1B application, it's roughly, anywhere between a couple thousand to $6,000 just in government fees alone if you pay for premium processing. So $100,000 on top of that fee is an insane amount to pay for one H-1B application. So that was one of the first kind of requirements of the proclamation. The second requirement was that this $100,000 fee, in addition to your USCIS fees, for any new H-1B petitions filed after September 20th, for those who are abroad would be applied. So that means if you are applying for a brand new H-1B petition as of September 21st, for anyone who's physically outside of the country, so that's a consular case, this proclamation indicated that you would have to pay $100,000 in order to get that petition processed. It does carve out an exception for some industries or jobs that are, quote unquote, in the national interest, and indicated that the Department of Homeland Security could announce in its discretion what those areas or jobs would be, but we haven't received anything yet on that. Last but not least, it also directs the Department of Labor to issue a rule that will eventually change prevailing wage levels for H-1B workers and prioritize the selection of H-1B lottery applicants who are getting paid at the highest levels. So more recently, we have an update on that, which I'll get to in a second. But these kind of updates, when it happened on Friday evening, kind of came out. The proclamation is very broadly worded. It was very confusing for many, many people, including lawyers, including H-1B holders and their companies. So over the weekend, many H-1B holders were rushing to come back to the United States before this proclamation took effect, because the way it's written, suggests that anyone who's in H-1B status who's abroad after September 20th would be subject to this $100,000 fee. Because this caused so much confusion, and later it was found out that the administration did not mean to include all of those people. The White House and the Department of Homeland Security and different White House officials had to come out over the weekend and simply clarify what they meant. And even though it started off as very confusing, here's what we know today. The fee, the $100,000 fee and proclamation, does not apply to those who held H-1B status or had a petition filed before the proclamation took effect on September 21st. So this means if you were an existing H-1B holder, already had a petition filed or pending, and you were simply abroad for, I don't know, a trip for some kind, or business trip, or you were applying for an H-1B visa stamp, you're not going to be subject to this fee, so not to worry. This fee also doesn't apply to anyone who's applying for an extension, a transfer or change of employer, an amendment, etc. Now, even though the proclamation's language doesn't quite match up with this guidance and some of these quote unquote clarifications that came out in the days that followed, the government has stated that this fee and most of the proclamation's requirements really only apply to new petitions. Now, those of you who either have an H-1B or know about the H-1B process, the new petition as a term, it can be defined in a number of different ways depending on what you tick off on the form I-129. The government has not clarified, and the president has not clarified what new petitions mean, but they have explicitly stated that it will apply to next year's lottery applicants. So this proclamation is intended to stay in effect for at least 12 months. So that will apply through the next lottery, and it could potentially be extended. The other clarification that the government came out with is that the fee is only meant to be a one-time fee and shouldn't be paid for future renewals. So those of you who are subject to this fee, even though this $100,000 fee is still insane and astronomical, the government at least has said that future renewals won't be subject to this. It's just a one-time for the lifetime of your H-1B. And last but not least, there was some confusion, and there admittedly, I think, is still confusion about this, but the fee and the rule should not apply to those who apply for a change of status while you're physically in the United States. Now, I say should not with a little bit of emphasis because the proclamation doesn't mention or address or define new petitions. And it also doesn't indicate that this should apply for anyone who's physically in the United States. The text of the proclamation actually explicitly calls out people who are physically overseas. But that being said, if you've taken all of the things that the government and President Trump have stated is one of the main purposes of this proclamation, in other words, incentivizing companies to prioritize hiring U.S. workers over foreign workers, and placing essentially an H-1B tax on new applications, it wouldn't surprise me if the administration came out with yet another clarification or an amended proclamation that addresses change of status petitions. But for now, you can rest assured that the change of status petitions for individuals who are physically in the United States should not be affected. Now, I think a lot of you who heard this news or affected by this news probably feel the same way and have been reading up in the news about this, but a lot of companies are up in arms and upset about this for understandable reasons. This is kind of a fee that is unprecedented, extremely expensive and cost prohibitive, and comes at a time where, the economy is down and also happened without much time to process. Again, the president issued this proclamation on a Friday evening, took effect on Sunday, almost a day and a half later. So while there aren't lawsuits yet that have been filed, we are expecting that there will be legal challenges to this rule. So more to come on that. Also, as you can probably imagine, the tech industry, who is one of the biggest kind of benefactors of the H-1B program, a lot of these small startups are affected by such a hefty fee. So, stay watching the news, keep updates with us, and stay logged into our socials. As soon as we hear more about this, we'll let you know. Related to this proclamation, there is another big change that's been proposed. On September 24th, so just about a week or so ago, the Department of Homeland Security issued a proposed rule that, if implemented, would drastically change the H-1B selection process, the registration process for H-1B lotteries, by getting rid of the normal or the randomized lottery process, and instead base selection rates on how high your offered salary is for the H-1B position. So this is huge. For those of you who have been in the H-1B space for longer than 5 years or so, you'll remember a time where this randomized lottery first became a thing in 2020. That's when the government introduced this registration selection process where companies submit names, essentially, and some minimal information about the candidates that they want to basically offer an H-1B position to for a new lottery process. And based on randomized selection for the most part, with the exception of those who are US master's degree holders, you guys have a slight edge, but it is still randomized, generally speaking. On April 1st or so, you would be selected, or you would at least know whether or not you got selected in the first round of selections to submit an H-1B petition. This rule would now get rid of that and instead mostly give priority to those who are getting paid the highest. So this new weighted selection process would assign more entries to higher wage levels. What that means is that it increases the chances for higher paid foreign workers to get selected, while still allowing some level of possibility of selection at all wage levels. So the goal of this really is to prioritize quote unquote higher skilled and higher paid H-1B workers. So this new proposed rule is a major shift, as many of you guys would probably agree. So bottom line, higher wage, higher chance of getting selected in the lottery. Under this system, the wages are categorized into 4 different levels, level 1 being entry level and level 4 being the most experienced. And registrations would receive multiple entries based on the leveling. So for example, if your H-1B position is categorized as a level 4, meaning it's the most experienced level for that occupation, and you're then, because of that, getting paid at the highest prevailing wage rate, your H-1B registration would receive 4 entries in the lottery. And it kind of goes down from there. So level 3 would get 3 entries, level 2 would get 2, level 1 would get 1. So this means, again, higher paid workers have a higher chance of getting selected, and entry level positions are still eligible, but just have lower odds. This also means that now for the next lottery season, if this is implemented by then, employers will need to include wage information during the initial registration process, whereas, in the past, that was not something that you needed to include at the outset. And the wage offered for petitions that are filed eventually must match the registration details. So changes with respect to that could be problematic. Now, the comment period for this proposed rule closes on October 24th of this month. And after review, what will happen is that the Department of Homeland Security will publish a final rule. And if that rule takes effect, it will most likely go into effect during next year's lottery. So this is a really big change that's being proposed. We'll continue to monitor this really closely and be in touch if it affects you or any of your employees that are expecting or hoping to be put in the lottery next year. Another H-1B update, lots of news for H-1B holders this month. On September 19th, the same time that the president issued a proclamation related to H-1B workers and that $100,000 fee, the Department of Labor announced a new initiative called Project Firewall. So other than the fact that that name is extremely cheesy, the goal of this program is to, quote unquote, protect U.S. workers by making sure employers are properly following H-1B rules and not misusing the program. So for some context related to this, the Department of Labor, for those of you who have H-1Bs or who are used to submitting H-1Bs, the Department of Labor is the agency that certifies LCAs, and the LCAs are part of the H-1B process. Now, on an LCA, you are required to disclose what the title of an H-1B position is, what the intended salary for that role is, where the work site will be, etc. And typically and historically in the past, their DOL has investigated complaints related to these LCAs or H-1B petitions, usually through whistleblowers or complaints that workers out in the general public can submit. And then based on those complaints, investigations would follow. This Project Firewall is essentially encouraging the Department of Labor, instructing the Department of Labor to proactively initiate investigations where there is reason to believe an H-1B employer isn't in compliance. Now, that's a pretty big shift from the usual complaint-driven system. So if violations are found during these audits or investigations, employers could face pretty significant consequences. So you H-1B employers out there who are concerned about this, definitely is a good time to take a look at your public access files, make sure all of your internal documentation is up to snuff. And if you haven't done an audit of your own files proactively already, I highly recommend that you do that. And if you need support doing that, definitely reach out to our team at McEntee Law Group. We can guide you through all the different compliance steps that you might need to know and might need to be aware of before the Department of Labor tries to initiate an investigation. So some of these consequences can include things like paying back wages to workers, paying civil penalties, and even being barred from the H-1B program for a period of time. So they're pretty serious, and it's really important at a time like this to have all of your documentation correct. This also goes to H-1B employees who are posting about their positions on LinkedIn or on social media. Make sure that, whatever you're posting online is, one, correct, and also make sure that if there are any consistencies between what you might be sharing online about your position at your H-1B company and what's been submitted to the government is consistent. And if there are some discrepancies, make sure to raise that with your legal team and your employer, so that if there are any compliance steps that need to be taken, so that they are consistent, that they're done before a problem occurs with the Department of Labor. Now, NIV visa stamping. As of September 6th, for those of you guys who are traveling and applying for visa stamps abroad, the Department of State is now essentially asking, but not really asking, all or most non-immigrant visa applicants to schedule their visa interviews at a U.S. embassy or consulate located in their country of nationality or residence. So historically speaking, many of you who were in need of a visa stamp to come back to the United States after an international trip oftentimes could do so in a country that you weren't a national of or didn't reside in previous to coming to the United States. Those applications were called third country national applications. And as long as the consulates accepted those types of applications, you were free to do that. So if you happen to be traveling to London, even though you're from India, and the London Post accepted your application for a visa, you could go there. Now, the Department of State, after this change, as of September 6th, essentially is saying that they're not barring you from going to London this time around, but they're indicating that if you do try to do that, there is a possibility that either one, your interview request could get rejected, or there's a higher chance of you getting a denial. And unfortunately, if that happens, your fees will not be refunded to you. So let's say if you're someone who's a citizen of India or Brazil, interview appointments, you should now go and make that in those countries. There can be some limited exceptions to these rules if there's like an emergency, or if you're from a country that does not have normal kind of routine non-immigrant visa services. So Ukraine is one example. There are designated posts for individuals like you that are posted on the Department of State's website. So you should go ahead and make sure you look if you do plan to travel. Long story short, international job seekers, students, travelers should expect more planning, stricter location rules, and make sure to check the appointment policies and timing in your home country consulates before you leave the US. For employers, be prepared for additional delays if employees need to renew or apply for visas abroad. So, and again, if you are from a country where there aren't routine non-immigrant visa services, check the Department of State's website to confirm your designated post. And this applies to, again, most non-immigrant visa categories with the exception of some. So when in doubt, please make sure to reach out to your legal team to confirm if this applies to you. We are now moving into TPS and humanitarian immigration status updates. So one of the biggest updates to provide this month has been related to temporary TPS or temporary parole program that allows for those who are from certain countries to essentially defer having to go back to those countries for a number of reasons, for humanitarian reasons. There are a lot of countries that are eligible for TPS, or a lot of nationals from countries that are eligible for this program. And there's been a lot of different changes over the last month or so. And when it comes to these parole programs, the picture is a little split. So the CHNV parole programs for Cuban, Haitians, Nicaraguans, and Venezuelans have been terminated after a Supreme Court ruling back in May. That means many who were relying on this will need to look for alternative legal options. If that is you, please reach out to our legal team and we could help advise you on if you have any other legal options and what the best next step might be after these programs are terminated. On the other hand, programs like U4U or Uniting for Ukraine are technically still active, but new applications are on hold pending further review. Current beneficiaries should be able to keep their status, but the program's future is still a little uncertain. So please, if you're on this type of program, watch for updates and keep in contact with us. Meanwhile, Afghan parole programs and military parole in place remain active with no changes reported. So business as usual there. We're also seeing a wave of terminations, unfortunately, along with several important extensions. So Afghanistan, Cameroon, Honduras, Nepal, Nicaragua, and Syria are all winding down with termination dates ranging into late 2025. While Haiti and Venezuela have been especially complicated, both of those programs saw attempts to end productions, but lawsuits have kept these programs alive, at least in part. So right now, Haitian TPS holders remain protected through February 2026. Venezuelan beneficiaries under certain designations have work authorization stretching into 2026, though litigation is still unfolding in these areas. So, please keep an eye out for that. I know a lot of this news was negative and maybe a little bit of a bummer, but it's not all negative. So we'll start with a couple of highlights here. A couple of TPS programs still are solidly active. That includes Burma, Ethiopia, Lebanon, Somalia, Ukraine, and Yemen. All of these programs are still in effect with expiration dates running well into 2025 and 2026. And importantly, some of the large groups like El Salvador, South Sudan, and Sudan have been extended. So this provides a bit of relief and good news and added flexibility and stability for beneficiaries and their families in 2026 for nationals who are benefiting from these countries' TPS programs. So again, the trend is overall mixed, but there are some longstanding TPS designations that have been cut back. Others kind of remain steady and extended. Lawsuits still are playing a huge role in all of this, especially for countries like Haiti and Venezuela, where courts have stepped in to preserve protections. But lots of changes in this space. So please, if you are a TPS holder, make sure to stay in touch with one of our attorneys so that you have an understanding of where the future of your TPS program might be. Now we're getting to our very last big update of the day. I know there are a lot more that we probably haven't covered, but of course, that might be good for our next month's First Friday. Something that has been probably on your minds or your employer's minds is fee increases. Many of you might have noticed that there have been fee increases with respect to a lot of immigration benefits, and many of those fee increases are based on something called the One Big, I don't want to say it, Beautiful Bill Act, the OBBA. We call it something else here in the office, but that is what the official name is. It was signed by President Trump in July 2025. And in a lot of ways, it changes many things. But one of the things that it does change for a lot of you applicants out there and your employers is that it imposes major increases and new fees on immigration benefits. So this especially affects humanitarian applicants and some employment-based applicants. But here are some highlights. The bill is many pages long, so I would have you here until probably next Thursday if we read through all of them. But I'll just cherry pick a couple just so you know what kinds of changes are afoot. So TPS applications and EAD fees increased as of July 22nd. So this fee to apply for TPS increased from $50 to $500. That is a massive increased fee. And the associated fee to apply for an EAD or an employment authorization document increased as well to $470. And that's with an online fee. Or if you file physically, it is up to $550 with no fee waiver available. So these are pretty big fee hikes for those of you who have been applying for these in the past. And unfortunately, this affects people who are coming from countries and coming for reasons related to humanitarian bases. So really devastating to see these fees go up so high. Another fee increase that we have seen are I-94 border increase fees. So the fee that you pay at the border to get issued an I-94 record if you're crossing at a land border crossing or whatnot has increased as well. And that is now up to, I believe, $30. There's also a new visa integrity fee that is $250. Now, there's been a lot of confusion about this visa integrity fee and when this takes effect. But this fee is related to those who are coming into the United States. If you are entering in as a traveler and either as a, on a B or on a non-immigrant visa, there may be a visa fee that will eventually be imposed. And it's intended to be almost like a bond that you post. And as long as you don't violate any of your visa conditions or terms, that fee is supposedly going to be returned back to you. So the moral of the story is there are a lot of different fees that are basically hiking. I don't think that there are any fees really decreasing. And in addition to that, fee waivers are mostly being eliminated here. So that's, again, devastating for humanitarian categories. And these are raising significant costs for a lot of vulnerable immigrants that need these applications to avoid, kind of devastating consequences abroad. So if you're in doubt, please look up the USCIS fee calculator. That is one nice thing that the government has provided us so that we can keep track of all these different fee changes. If you have any questions about things that might affect you, these fee hikes that might affect you, reach out to our team. Now we are going to move into another part of our First Friday here where we're done with our big updates of the day, but we will get to a couple of comments and questions that have been submitted by those of you in the audience. So we appreciate those who have submitted questions. And if that was one of you, stay tuned. This is for you now. The first question we're going to get to is, can I know what time an I-129 petition will start getting approved for the H-1B visa? So that's a great question. And for those of you who have an H-1B pending with USCIS right now, I think I mentioned that the government shutdown will not affect the pending applications. So your cases will continue to be processed, which is good news. In terms of what the timeline is to get an H-1B visa approved at USCIS, it really depends on the type of case that you filed and honestly which office it's sitting at. There is a website online. It's called gov.uscis.gov/processing-times. If you go to that website, you can actually look up what the government's posted publishing times are for any case type. Again, that's egov.uscis.gov/processing-times. But change of status applications for H-1Bs are currently taking about 3.5 months. Consular applications are taking about 8 months. Extensions are taking about 7.5 months. So these are on average. Some cases can be outliers. So if you are concerned about a case that's taking a little bit too long, reach out to your attorney, reach out to us so that we can help you see if we can request an expedite or see what's going on with your case. Second question from the audience. My I-45 got denied and I'm a minor. What are my options now? So first of all, whoever submitted this, I'm extremely sorry to hear that your I-45 got denied. I know that the green card process is extremely lengthy and often really stressful. So receiving a denial at the end of that long journey can be really devastating. So That said, I will say that this kind of question completely depends, the answer to this completely depends on your specific situation, why you got the denial, whether or not there is any opportunity to refile, and if not, whether there's anything in your background that could give you status so that you can kind of regroup and figure out a next step forward. So for the audience member who submitted this, please reach out to our team if you don't have an immigration attorney already working with you on the I-45, so that we can set up a consultation and talk to you about your specific situation. Next question is, if you have an H-1B, can you go to school? That's a great question, and one that I get pretty often. H-1B visa holders, it's a common misconception that H-1B visa holders cannot study. However, it comes with some caveats. So H-1B visa holders are allowed to study part-time without changing status, but you have to make sure that if you do plan to take some classes at your local college or enroll in a part-time program, that the terms and conditions of your H-1B visa that's currently approved are not affected. So if you are working full-time and that's what's listed on your petition, if you're working as a software engineer at a certain location and that's what's listed on the petition, that should all continue to be status quo. You should continue to fulfill the obligations of your H-1B because that's your primary visa. So you cannot necessarily work for another employer while you're on H-1B unless you have a separate H-1B approved for them, but you can take classes and work part-time. Now, last question, if your grandparents are US citizens, can you get citizenship? So this is a maybe, and one that would be amazing for you to reach out to our team for, because we do have amazing attorneys who work on family-based cases and could be able to guide you through this question. The answer to this question is potentially yes. So there are ways in which your grandparents' citizenship could potentially benefit you in a citizenship case, but there are certain conditions that have to be met. So again, this is kind of a personal question. It would be great to have a consultation directly with one of our attorneys so we can kind of guide you through whether or not you specifically could be able to benefit from your grandparents' citizenship and what kind of factors we need to meet for you to be able to do that. And without further ado, I think that concludes the question and answer period of our first Friday. I don't see any other questions coming through the stream. So I'd love to thank everybody for tuning in. I know there were a lot of updates this month. I also know that immigration right now is a challenging time, I would say, and that's putting it really lightly. But for those of you who are listening, just know that there are legal advocates and legal teams out there that are here in your corner and that will fight for you and advocate for you. And that includes our team at McEntee Law Group. So if you want to stay in the know about news, please follow us on our socials. That includes Instagram, TikTok, LinkedIn, Facebook, YouTube, and X. For those of you who are not yet visa holders but are watching from abroad and might want to consult with one of our team members for a visa, we have a range of ebooks and resources as well for those who are in the startup world, those who are in the content creation world. Specifically, we have actually ebooks for U.S. immigration options for startup founders and O1B guide for content creators. So please email us for these resources. In addition, if you want to be subscribed to any of our newsletters, please go ahead and email us at info@mcenteelaw.com or social@mcenteelaw.com. You can also find some of these resources on FionaMcEntee.com. And last but not least, if you have any specific questions or want to reach out to our team about your case, please do. You can find us online. You can book consultations directly with one of us on our website, and we'd love to talk to you and we'd love to meet you. So with that, thanks so much, everyone, for tuning in, and happy October. Stay safe, and we'll see you next month.